Hello everyone, and welcome to today's webinar, Texting Patients 201, Reducing the Fear of TCPA Compliance. My name is Rachel Arnold. I'm the Notifications Marketing Manager for West. I want to thank you for taking the time out of your day to be with us. Before we get started, I wanted to go through a few administrative notes. First, due to the high attendance and short time frame today, may not have time for a Q&A session, so please feel free to use the question box that you see to the right of your screen to submit any questions you have throughout the presentation. You can also email questions directly to healthcareideas@west.com. Second, for those of you who may have to leave today's webinar early, we will be sending a recording of the session to everyone who registered within 24 hours of today's presentation. And lastly, we're discussing the Federal Communications Commission's rules and regulations for the Telephone Consumer Protection Act. However, we want to remind you that this presentation is informational only. We're not providing legal advice, and we suggest you consult your counsel for advice related to your organization specifically. I want to introduce today's presenters and tell you a little bit about their experience with compliance and regulations. Today you'll hear from West VP and General Counsel Jeanette Nelson, as well as West Compliance Specialist Rebecca Johnson. Jeanette has been with West Corporation for over 13 years and is responsible for regulatory compliance as well as privacy within our organization. She holds a law degree from Creighton University as well as an MBA and is a certified information privacy manager for the U.S., Europe, and Canada with the International Association of Privacy Professionals. Rebecca is also a certified information privacy professional with U.S. and international compliance knowledge covering communication channels, telemarketing, SMS, push notifications, privacy, security, and other federal and state laws. She has been with West Corporation for over 8 years, serving as a liaison between our legal team, executives, and internal departments to ensure regulatory compliance for our organization and our clients. Our goal today is to provide you with enough information over the next 30 minutes so that you can leave today's sessions with a clear understanding of the Telephone Consumer Protection Act and what you can do within your organization specifically to ensure your communication strategy is compliant and successful. We'll start off by discussing a few text messaging trends and the potential values communication channel could bring to healthcare. Then Jeanette will lead you through an explanation of the TCPA, how it applies to text messaging, and how it applies specifically in a healthcare setting. Finally, Rebecca will conclude our presentation with some best practice guidelines to help you maintain TCPA compliance and maximize success with your patient communication strategy. So let's get started. As you can see on the first slide, we have a few stats from the Pew Research Center that give us a little insight into the growth of text messaging as a preferred communication channel, as well as the value that it could potentially bring your healthcare organization. Let's take, for example, traditional mail. Because the cost savings and successful delivery rates with electronic mail continue to exceed that of traditional mailing, most businesses and organizations are moving to digital outreach. You can see this in your own inbox, but you also should know that this means your patient's inbox is busier than ever with emails from various businesses and organizations that they encounter every day. So if you're trying to reach your patients via email, you could be waiting on average 2 days to receive a response from them. However, as you can see here, if you send a text message, you could achieve a patient response within 90 seconds on average. So just consider the impact on your daily schedule, office efficiency, and communication costs if you could receive an appointment confirmation or cancellation request within 2 minutes of sending a reminder, instead of waiting the potential 2 weeks it would take for a patient to receive a printed or mailed postcard and then act on it. The value of text messaging doesn't stop just at your organization. 70% of patients indicate receiving text from their healthcare providers would be a value-added service. The Pew Research Center also found that consumers are sending, on average, 42 texts per day. So if we assume your patients are even close to this average, how convenient and easy would it be for them to communicate with you using the same outlet that they're already using every day? But it doesn't take a bunch of these stats and figures to see that text messaging is growing. You can look around you and see everyone on their cell phones at any point during the day, or consider your own usage habits. The power of text is getting pretty hard to deny. However, as with any new technology you introduce in your organization, it is good to be knowledgeable of the associated risks and create a plan to avoid them, which is why we're all here today. The good news is the risks we are discussing are easily managed. With that, I'm going to turn it over to Jeanette, who is going to shed some light on the federal rules and regulations that apply to text messaging and healthcare specifically. Jeanette, take it away.
Thank you, Rachel. So the Telephone Consumer Protection Act was passed in 1991 when cell phones weren't all that prevalent, but there's a section in that act that prohibits calls to cell phones using automatic dialing equipment, a pre-recorded voice, or a text message, and the FCC has made it clear that a text message is considered a call within the statute. That prior express consent is required unless the call is for emergency purposes, which is defined on the slide. It's a call made necessary in any situation affecting the health and safety of consumers. The TCPA also prohibits pre-recorded telemarketing calls and texts or calls made with automatic dialing equipment to cell phones without prior express written consent of the called party. That written consent, there's a definition in the statute for that written consent and includes some specifics, which includes having a signature. It can be electronically signed, but there are some specific requirements for that written consent. Pre-recorded marketing calls to landlines also require that same express written consent. Why it matters so much and why we're talking about the TCPA, and you've probably heard a lot about it, is that the TCPA provides for a private right of action. Consumers can sue for up to $500 a violation, which can be per call or per text. If the violation is shown to be willful and intentional, that amount can be tripled. So what we are seeing is an enormous amount of litigation in this space, and they quickly become class action lawsuits. There have been many settlements in the tens of millions of dollars from a variety of industries. So it's important that we pay close attention to our compliance with the TCPA. In 2015, the FCC issued a declaratory ruling, and it addressed 21 petitions that various companies had filed seeking clarification regarding the TCPA. They released that ruling on July 10th, and it became effective on that day for the most part. They clarified a number of issues. They started with the definition of an auto dialer. While the statute defines it, the FCC has broadened that definition over the years, and this ruling added on to that definition. So it's essentially equipment that has the capacity to store or produce numbers and dial them using a number generator, and that includes if you're dialing from a list of numbers. The FCC, with regard to the word capacity, made it clear that it's current capacity for your dialer and future capacity. So if there's, they use the term, I think, theoretical possibility of converting your system into an automatic dialer, it's considered one today, even though it may take some work. Now, what level of work that means, we're not really sure yet, so we anticipate probably some litigation in this space. They also went on to clarify that the call initiator is the person or the entity who takes the steps necessary to place the call. Another big clarification was who is the called party. There were many petitioners seeking to have the FCC designate the called party as the intended recipient. The FCC declined to do that. They came forward and said the current subscriber to the cell phone or the customary user of that number that's included in a family or business calling plan is the called party within the statute. This is really important when it comes to numbers being reassigned. You may have a patient that has a phone number, you think you have consent to call it. They don't tell you that they've given up that number, it gets reassigned to someone else, and you make a call to that and you do not have the consent anymore. There is what the FCC determined a one-call safe harbor, although one call, whether the patient or customer answered or not, is deemed to be notification that the number has been reassigned, which is a little bit silly, but that's how they wrote the one-call safe harbor. The FCC also clarified that text messages, SMS, are subject to the same protections as voice calls, as I said just a little bit ago. And then equipment that's used to originate internet-to-phone text messages to wireless numbers via email or a wireless carrier's web portal is an automatic dialing system, and those calls then are subject to the TCPA. Within the ruling, the FCC issued a healthcare clarification. They stated that if a patient provides a number to a healthcare provider, that does constitute prior express consent for calls that are subject to HIPAA by a covered entity or a business associate acting on its behalf. The calls must be within the scope of the consent given, which means closely related to the purpose for which the number was provided. That means if they, made an appointment or they're in for an appointment reminders, bill ready, lab results, things that are related to that appointment are considered closely related. If you're going to send something outside the closely related purpose realm, then you need to get the true prior express consent. Provision of the number is not sufficient alone. They also clarified that a third party can provide consent on behalf of an incapacitated person, but that consent is invalidated once that period of incapacity ends. The FCC also issued a healthcare exemption from the prior express consent requirements for calls where there's an urgent need or a healthcare treatment purpose. Those are listed on the screen. They have to be made by or on behalf of the healthcare provider, pre-op instructions, appointment and exam confirmations, post-discharge follow-up. There's a list of things there that they consider to fall under the healthcare exemption. Unfortunately, the healthcare exemption came with a number of restrictions, the first of which that they can only be sent to the wireless number that's provided by the patient, which is very similar to the healthcare clarification we just talked about. There's a list up on your slide of things that are required in the healthcare exemption, the restrictions that apply. They cannot include any marketing or solicitation, advertising, bill collection. They must comply with the HIPAA privacy rules. Voice calls must be 1 minute or less, text messages 160 characters, and then no more than one message per day up to a maximum of 3 per week, combined from a specific healthcare provider. There must be an interactive opt-out on voice calls and a stop on text messages. Opt-out requests must be honored immediately, and the biggest restriction to this exemption is that they must be free to end user, and that includes not being counted against any plan limits on, limits on text or limits on voice minutes. That makes it very difficult on the voice side because you never know what kind of plan a person may have. And on the text side, it would require a free to end user shortcode to be used. So while the healthcare exemption has maybe some use, it's limited by these restrictions. So now I'm going to turn it over to Rebecca to talk about some of the implications and some things that you can do to help you with your text messaging.
Thank you, Jeanette, for providing the legal framework around the use of autodialers. So now that we know what we should or should not do, the next question you may be asking yourself is, what does this mean for my organization? How do I make these rules actionable? What decisions should I be making now? And what are the processes I need to develop to manage these requirements? In true legal fashion, the first step is creating a policy. Over the past year, I've seen an increase in formalized policies from organizations outlining their course of action to the TCPA. Naturally, these policies will include elements of privacy and security, but for this course, we're just going to focus on TCPA. Your legal, privacy, security, and patient engagement representatives should participate in the development of a patient engagement policy. This policy would not only cover texting requirements, but any communication channels used to engage with patients. Some of the TCPA components in your policy could include how you will establish prior express consent. Go ahead and call out the clarification from the ruling we just covered if that is the definition of prior express consent for your organization. If you intend to deliver messages that are not closely related to the purpose for which the number was provided, then identify how you will collect, store, and manage this consent. And again, this is typically driven by your legal department. Secondly, identify required disclosures with a consideration to the method used to obtain the prior express consent. For example, specific to texting disclosures, it would include your consent language for texting, confirmation of opt-ins, consent confirmations, and any reconfirmations of consent that you might use on the channel. Approved message content is critical for an organization to define, and one of the areas where good intentions will bring TCPA risk. Message content is derived from considering the purpose, intended audience, and your communication channel. In this section, you will identify data elements, for example, your PHI or PII, whether it's allowed or restricted, when to use right party verifications, any disclosures that you need to have in the messages, specific greetings, and also consideration of your length limitation, not only for the voice channel, but for the text channel, which is 160 characters. In developing a TCPA compliant engagement strategy, you'll also need to consider how and where you're going to capture patient preferences and managing the opt-out. So let's dive a little deeper into these two topics. Consent is at the core of patient preferences. Capturing and adhering to these preferences is how you honor the consent. The technology can greatly assist in this space, and at a minimum should allow your patients to provide consent and revoke consent. Specific to the text channel, this can occur through texting START to join a shortcode program or STOP to revoke their consent. For those not familiar with texting shortcode programs, this is simply a dedicated communication line, much like a telephone number, that allows a patient to subscribe to communication through that program. The shortcode is a 5-digit number designated to your organization. On the screen, you're going to see an example of a solicitation message. And I'm calling this out here to remind you of the risks associated with solicitation text messages and what they just might look like. If you are collecting consent to the healthcare clarification for consent, which is, again, the provision of the phone number by the patient, you cannot send solicitation text messages. Going back to your policy best practice, if you do not want to capture consent specific for solicitations, then you should restrict your business leaders from using the text or voice channel for that matter. Solicitations are allowed, but there are additional federal and state regulations that must be evaluated before doing so. To continue the conversation of patient preferences, patients should be able to revoke, or we may use the word opt-out, for receiving text messages. The TCPA is very clear on discontinuing text messages when consent has been revoked. Again, technology can greatly assist in this area by managing and storing the opt-out request. Opt-out requests can come through various means, such as verbally at the front desk, via your website, or from the mobile device itself. Create a central location for the opt-out to be stored. This can be stored and managed by you, or you can leverage solutions on the market. The key here is to ensure no further communications are delivered to a mobile number once consent has been revoked, and this happens through a single source of truth of your opt-in and opt-out data. Integrating compliance requirements into your patient messaging strategy is essential to reduce the risks around TCPA violations. But those aren't the only areas to consider when striving for an effective messaging strategy. Texting is a great channel for communication, but it isn't the only channel patients want to hear from you. Integrate voice and email channels into your overall strategy. Allowing multiple channels gives patients the ability to choose a preferred channel. Your patient demographic covers multiple generations, and they each come with their own preferences. While language options may not be essential for every organization to provide, just know there are options in the technologies to give this additional layer of preference. The last two items are often overlooked and not managed. Success in deploying a communication channel in one area of your organization can create buzz through other divisions, and it's natural to apply the same strategy to the other division because it's just easier that way. But that isn't always best. Without oversight, you could lose sight at how many times a day you are actually communicating with a single patient. Before understanding the right cadence, let's take a look closer at email, voice, and the text channel. Email, voice, and texting may reach the same patient, but the information shared and the invasiveness of the channels are going to vary. When dealing with patient information, some channels just may not be appropriate for the message you want to relay, or it doesn't support the type of response you need from the patient. Avoid over-messaging and take communication channel into consideration when planning your message timing and content. When it comes to TCPA lawsuits, some of these start because an individual felt harassed, For example, the doctor delivering an appointment reminder every day starting 5 days before the appointment. To reduce risks in this area, set processes and boundaries for how and when you communicate by considering the message to deliver, the appropriate channel, and the frequency of messages through that channel. The best strategies are going to be when you incorporate all three. So let's take a look at an appointment reminder strategy, which most all of you can relate. The goal is to reduce missed appointments. Common reasons for patients to miss appointments are, I forgot I had an appointment, or I knew I had an appointment and couldn't make it, but I forgot to let you know and reschedule. Utilizing what we know about email, voice, and text channels, we can establish a compliant cadence and frequency. 1 week prior to the appointment, the patient will receive an email, which could include a confirmation button, address, link to reschedule appointment, and additional information related to the visit. The voice call would reconfirm and remind the patient of their appointment and which doctor they will be seeing a couple days prior to the appointment date. For the day of, a text message is great to include the time and an address link to be opened in their MAP program for their convenience. This is not a one-size-fits-all strategy. Consider your objective, whether it's reduced missed appointments, reduced bill payment turnaround, increased immunizations, whatever the strategy may be. Combine your objective with the type of message to be delivered, and then create a strategy for each. This is a best practice not because it is easy, but because it is strategic, thoughtful, and compliant. This will result in a higher ROI from your patient engagement strategy, and you're going to reduce the risks of noncompliance to your organization. Let's look at a case study where they went from a single channel to a multi-channel strategy while integrating patient preferences. Vanderbilt had experienced a consistent confirmation rate of approximately 30% through their voice calls. This means that upon hearing the phone message, 3 in 10 patients would press a button on their keypad to confirm their appointment. Allowing for patient preference and appointment reminders has increased response rates across the board. Since giving patients the option to receive a text message instead of a phone call, confirmation rates have reached 65% among those who have opted for text. Now that patients with a preference for text have been removed from the voice group, confirmation rates among the voice group are now up to 37%. That's a 23% higher confirmation rate than the historical average for those patients. After the first month of availability of texting, 10% of appointment reminders to Vanderbilt's patients were delivered via text. 7 months into the program, Vanderbilt noted that text now accounts for 28% of all appointment reminders. Rather than opting every patient in on a mass level, Vanderbilt prefers a more organic, kind of patient-driven approach to opt-in. Schedulers consult with patients on an individual basis to help them select the preference for how they will receive appointment communications moving forward. With the elevated cancellation rates, they created strategies around filling those cancellations through outreach to their waiting list. This is just the first success among many as they build their multi-channel communication strategy. Again, I want to thank you for your time today to attend this presentation. We hope that you found it valuable. And there's some key takeaways that we would like for you to consider, such as TCPA does in fact apply to text messaging as it does the voice calls. Same law, same rules applied. The FCC's ruling provided the clarification for prior express consent specifically to healthcare. Review this with your counsel to make a determination for your organization. The first step in compliance best practices starts with defining policies and procedures around not only the text channel, but also voice. Make it clear to your organization how you will be compliant. Consent and revoking consent should be documented, stored, and managed. Make use of available technologies to perform validation checks before sending a voice call or text. Being compliant is one step toward reducing risk. Integrate compliance into your multi-channel strategy while considering your patient's preferred channels. Bottom line, TCPA compliance is achievable in a way that will not hinder patient engagement.
Okay, thank you, Rebecca, for going through some of the implications specifically for providers in the healthcare industry. We want to thank everybody again for coming today. We hope that you're able to take away a better understanding of the rules surrounding patient communication, as well as some actionable best practices that you can make in your practice or organization by adding text message or automated communication. I'd like to thank Jeanette and Rebecca for their time today and encourage you to send any questions you thought of during our presentation or any that may come up once you had a chance to digest the information to healthcareideas@west.com, and we'll be sure to follow up with you as soon as possible. Within the next 24 hours, you will receive an email from us containing a link to a recording of this webinar as well as a copy to the presentation. You can reference it again in the future or share with colleagues who may have missed today's event. I'd like to also call your attention to our newest free resource. If you're a current client, you may have seen this in our monthly newsletter. For the rest of you, it's a white paper that discusses some of the topics surrounding TCPA compliance and patient communication best practices like we've discussed today. If you'd like a free copy, you can go to televox.com/compliance guidelines to request one. Lastly, once you end your GoToWebinar session today, you'll see a short survey pop up. If you could please take a few minutes to complete that short survey and provide us with some feedback, it'll help us continue to improve our webinar offerings and make sure we're meeting your needs. That concludes today's event. Thank you for coming and have a great day.